IFM Below 40 webinar on Secretaries and Arbitral Tribunals, a Burden or Opportunity. My name is Anna Tujakowska. I'm a Senior Counsel at Sołtysiński-Kawecki-Ślęzak and a co-chair of IFM Below 40. And together with Karolina Czarnecka from Quartus, we will be moderating a very interesting discussion on the secretaries. Before we will move to introducing our distinguished guests, some housekeeping issues. We will have our webinar in half recorded. The half applies to discussion between our guests. However, the moment we will move to the discussion, the recording will be switched off because we want to encourage a free discussion among our participants, and the chat room rules will apply, which means that anyone who comes to a meeting is free to use the information from the discussion, but is not allowed to reveal who made the comment. Throughout the whole webinar, you will have we have the chat option available, so you can use it freely. However, if you want to ask the question, please use the question and answer box. You will be muted through whole the webinar. However, we will want you to participate and ask your questions. So please use the hand avatar if you want to ask the question yourself, so we will be able to locate you and unmute you. If you prefer to just type the question, please use the chat box, the Q&A box, and we will read the question for you. And now I would like to ask Karolina to start the honor with introducing our guests.
Thanks, Anya. Thanks a lot. Our first speaker is Bronte Hanna. Hi, Bronte there. Bronte is an Australian lawyer practicing international arbitration in Germany. She's an alumna of the International Dispute Resolution LLM in Humboldt University, Berlin. Currently, she is a senior associate in CMS in Munich. She has acted as counsel and administrative secretary in various international commercial arbitrations, primarily under the DIS and ICC rules, as well as investor state arbitrations. Great to have you here today, Bronte.
I'm so excited to be here, and greetings from Munich, and thank you for the invitation. I look forward to a lively Thursday afternoon discussion with you all.
And our second guest is Dr. Ole Jensen. Ole is an associate in the Litigation and Controversy Department and is a member of International Arbitration Practice Group of Wilmer Hale and is based in London. He has an experience in arbitrations under a variety of and ad hoc and institutional and ad hoc rules, including ICC, LCIADs, and ancestral rules as a counsel and as a secretary to the tribunal. He also acts in the state court proceedings related to enforcement and annulment of arbitral awards. Ole also speaks regularly on international arbitration issues and is assistant editor to the Journal of International Arbitration. He is an author of many publications on international law, but the most important from today's point of view is the book on tribunal secretaries in international arbitration, which was honored with 2019-2020 DIS Sponsorship Award. Great to have you, Ole, today.
Thanks very much, Anya. And you can imagine how thrilled I was about the invitation. You know, having sat in a library for 2.5, 3 years working on the topic, now I finally get to talk about it. So that's great. I'm looking forward to it.
We're looking forward to this as well. And before I will get some questions to you, I would like to thank Karolina and Alicja Zielińska-Eiser for the idea of this webinar. And I have to admit that it's not only for IFM Below 40, but also for me, a bit of a walk down the memory lane, because in 2014, when the young ICA published the guidelines on arbitral secretaries, this was a new chapter for IFM. We had a conference on the very same topic on the secretaries with Professor Anna Thier and Ulrike Gattenberg, who was a member of the task force who prepared the report. We also launched a Polish version of the ICA guidelines, I had a pleasure to author. And this brings me to the first question that I have to Ole. Tell me, what has changed since 2014 and the launch of the guidelines? What was the reaction of the institution, if any? What's your take on this, the landscape that this left after the 2014?
Thank you. And I think it's very clear that there was a strong reaction. If you look at the landscape pre-2014, pre the Young-Icker Guide, institutions didn't generally say much about tribunal secretaries. You had a few exceptions. One exception being the SCI, the Swiss Chambers Arbitration Institution, in the Swiss rules. They had a provision on tribunal secretaries, which is basically due to a historical fact that the 1969 Swiss Concordat actually also had a provision on tribunal secretaries. And from what I can see, that is pretty much the first international state regulation on tribunal secretaries, and then historically that went into the Swiss rules. Similarly, also for quite some time, since 1988, the ICC had a soft law or guideline on tribunal secretaries. There were different iterations on that instrument, and now it's moved into the ICC notes to parties and arbitral tribunals. But other than that, you didn't really, have institutions addressing tribunal secretaries, and that has fundamentally changed, I would say. If fast forward 7 years to 2021, if you look at new updates to arbitration rules, you see a whole paragraph on the tribunal secretary in the 2017 SCC rules. You have detailed regulation in the 2020 LCAA rules. You will find a secretary in the 2021 ICDR rules. And those are only a few examples of institutions that actually put the secretary into the rules rather than a guideline that applies to arbitrators and parties. On substance, I would say, the Young-Icker Guide has aged very well. There would be no reason to, update it or refine it, I would say. It's rather that if you look at these institutional rules, that they more or less follow what Young-Icker proposed. In terms of the appointment of the secretary, you might say it was somewhat novel for the Young-Icker Guide to require the party's consent for the secretary to be appointed. That was not a requirement, for instance, under the Swiss domestic arbitration law, where a tribunal could appoint a secretary over one party's objection. But that is very much included, the requirement for consent, in the 2021 ICDR rules, 2020 LCAA rules, 2017 SCC rules. So I think it is fair to say that the current standard is for a tribunal to, provide the parties with the CV of the secretary, with a statement of impartiality and independence, and then, request their comments, if any. And on substance, I'm not going to go into that because I think we'll discuss that in a bit more detail later on. But the Young-Icker Guide was quite novel at the time in being specific or explicit about the fact that secretary assistance could go beyond the purely administrative. In that assertiveness that the Young-Icker guidelines had, that was rather new. And then they also list specifically what a secretary might do. And if you now look in the new LCAA rules, SEC rules, you will find a provision saying the tribunal may not delegate its decision-making function or authority, but the rules themselves do not get much more granular than that. But I think it's quite clear that there may be no delegation of decision-making authority. And then the million-dollar question is, what does that mean? And what specifically is it that secretaries can do? So maybe as a quick summary, what has changed is the institutionalization of the secretary position. It's now, a legitimate and recognized actor in arbitral proceedings, and the acknowledgement that certain tasks can go beyond the purely administrative. Thanks.
Thank you. So that's the theory, and the practice. It's do we know whether the secretaries has been used more often? There are any data available, maybe on the current data on the use of this institution?
For a long time, data was rather hard to come by. The Young-Icker had conducted surveys in 2012 and 2013, which were, the first larger scale data we could get. But now, actually, as of this week, we have the numbers that the LCAA court publishes on the casework report, the LCAA cases that came in 2020. And you can actually see that they include a section on tribunal secretaries. And it's quite interesting to see how out of 400 new cases, you have a formal secretary appointment in 39 cases. So we're not even at 10% if you assume that the case is initiated in 2020 would also have a secretary appointment in that year. So yeah, that was the theory. The practice, at least in LCA arbitration, seems to be different.
So it seems that there is a huge space for improvement and development. And we have with us Agnieszka Grabowska-Łoszyszyn from court here in Warsaw. And I would like to ask Agnieszka, what's the point of view from on the secretaries of the court? Can you just shed some light on the practice and theory from your point of view? I think you have to unmute yourself.
Okay, thank you. Yes, of course. I will quickly present feedback with the legal basis in SAKIC and the reality of appointing tribunal secretaries. SAKIC, as a permanent institution, has regulated that tribunal secretaries in this statute, which is in force from 1st January 2019, and in its Article 11. Administrative secretaries provide a few rules, which are, let's say, quite procedural guidelines for arbitrators and tribunal secretaries. Firstly, it provides the possibility to create a list of recommended secretaries, quite similar to list of arbitrators. Secondly, it does not specify exact duties of secretaries, but kind of activities, mainly editorial and technical activities. Then every duties must be carried on request of arbitral tribunal under supervision, under its supervision and instructions. And there is, if she or he agrees to be secretary, then the written statement is required on his impartiality and independence, and having time to perform his duties, her or his duties. And last but not least, in Article 11, statutes regulate the remuneration of the secretary, which shall be borne equally by the member of the arbitral tribunal, and under no circumstances may be passed on the parties. The agreement should be signed with the members of the arbitral tribunal. And this is the legal basis, the theory. And what is the practice? The practice is that in last year, 2020, while every year 150, 200 claims are filed with SAKIC. So last year we had 2 cases in which the presiding arbitrator officially notified the secretary to the court and to the parties. The secretary made a written statement and participated in the proceeding, but there was we haven't get any agreement, and we don't know what was the remuneration with arbitrators. It wasn't with us. So as you can easily count, it's not even 10% like in LCIA, as Ole just said, but it's 1% of cases. And yes, it's the data from permanent arbitral institution with secretary and people who carried the arbitral proceedings. So, but it's not time for diagnosis. It's only just quick feedback. So that's it.
Many thanks. I think that's still a long way to go, but hopefully this webinar will do something about that. So off to my question, maybe it's a very basic one, but I think it's pretty an important one. What is the secretary's function, and how can it be used to the fullest? Meaning, how not to limit the role just to administrative tasks. Bronte, what's your take on that?
So I think the name gives it away. A tribunal secretary, the function is to assist the tribunal in their case management. So there will be a few factors that affect how this is done. One of them might be, as Ola suggested, or as we've heard, that the institution might somehow define The role, I should have already stated, sorry, that there is no strict definition. And Ola can sing us a song about this because he spent years trying to define it. So the institution might provide guidance on this. It will also depend when you work as a secretary, who you're working for. It's very important to pay attention to the preferences of your boss, of the arbitrator and the tribunal. And lastly, what you can do is agree on a terms of appointment with the parties and the tribunal and the secretary. And this also answers your question on how to get the most out of this function, because you can operate in a very transparent manner and you're going to reach the aim of the game, and that's to increase the efficiencies of the proceedings. And just a very basic example might be if you define that the secretary is allowed to send email correspondence to the parties, that just makes such a big difference in the day-to-day practice of the secretary then. So that, did I answer all your questions? Yeah.
Absolutely. Thanks a lot.
So we already established for now that the secretary it's a function that is not used in the fullest, because it's from 1% to 10% of the cases that actually take advantage officially of the function of the secretary. And I'm thinking, what is in that case the main impediment of using the tribunal secretaries? Why we don't see more and more cases when we have all these rules and guidelines in place? And I was wondering, what is it? Is it the specific arbitration rules, the way how they're structured? But what Ola just said, there is a framework for clear use of this function. So maybe it's arbitrators' lack of awareness that you actually use the secretary, this function, and actually benefit from it. Or maybe it's a fear of having an award set aside, because all of us heard of the very famous or infamous UCOS case when the issue of the arbitral secretaries arose. So I'm trying to understand whether we are able to put a diagnosis and which of the issues it's actually impediment in that case. Ola, what do you think? Which factor is here in play?
Yeah, I think that's a very important and fascinating question, which I actually, before looking at these numbers, before now hearing from Agnieszka that it's 1%, for instance, at the Polish Court of Arbitration, I wasn't aware that there was a big impediment, but that very much seems to be the case. And then thinking about what could be the reasons, what you mentioned could be good reasons, but I think at the end of the day, it's mostly psychological. And it maybe pre-UCOS, pre the Young ICA guide, pre all of the discussion on secretaries, it might not have seemed worth it so much, bothering the parties at the beginning of their case with the appointment of some fourth person or assistant. So that one has rather, kept it internal. But as Bronte said, even something as basic as sending correspondence on behalf of the tribunal, if the arbitrator, the presiding arbitrator, is in deliberations in a hearing or whatever, and something needs to go out quickly, that could not have been done without appointing someone formally. So there's very, very good reasons, and many of them, to appoint them formally. With regard to these psychological barriers, you already mentioned, Anya, the cases that we've seen both before and after the UCOS challenge. And if we do assume an impediment, we might call it tribunal secretary paranoia, as we call the reluctance to make, procedural management decisions sometimes as due process paranoia. And as in the case for due process paranoia, there's no reason for tribunal secretary paranoia, I would argue. And that becomes quite clear if you actually do look at the case law that we have. And there were, in fact, after UCOS, quite a few other famous, or at least cases that were discussed widely in the field, which was one case by the English High Court, P&Q of 2017. In that case, and I won't bore you with the details, but in that case, the premise of a challenge to the entire tribunal was that the presiding arbitrator meant to forward a request from the respondent to the tribunal secretary, asking for the secretary's reactions to that request. And inadvertently, the arbitrator replied and sent it back to the respondent. And that prompted a challenge, and it went through the LCAA court. which rendered a extensive decision, which is definitely worth a read, and it's published. And then it went to the English High Court, and the High Court in the end was very clear that in that case the secretary had been formally appointed, which was important in the court's reasoning, but that once the secretary is formally appointed and no tasks are defined, then it's up to the discretion of the tribunal how to employ the secretary to the level of delegating tasks that are crucial to the tribunal's mandate, but that wasn't reached in that case. There are other cases, as I said. There's a Swiss Federal Tribunal decision of 2015 to the same effect. There was a Svea Court of Appeal case, which would have been interesting because in that case, the secretary was actually a full professor of law that was appointed. And that is, of course, rather unusual, where you would have otherwise more junior people. And then, of course, you have the UCOS decision by the Court of Appeal in The Hague that very much went along the same lines as the English High Court, stating that we did have a formal appointment of the tribunal assistants in that case. That formal appointment could have been communicated better, is what the Hague Court of Appeal said, because the presiding arbitrator in the UCOS case only mentioned at the outset of the case that the assistant would be someone the parties could reach out to if there were any questions. But other than that, the Russian Federation in its challenge handed in expert reports on who drafted which parts of the award, and the Hague Court of Appeal was not convinced that this indicated some kind of improper delegation by the tribunal. We also have, since last month, the Advocate General's opinion on that case. The Dutch Supreme Court, where the case is pending now, has an Advocate General who, similar to the Court of Justice of the European Union, gives advice. And he also agreed with the Court of Appeal that this is not a ground for annulment of the award. And we will see when we get the Supreme Court decision, which will very much be an end of an era between 2014, when the challenge was first lodged and became public, to a final determination by the Dutch Supreme Court. So maybe to summarize or to wrap it up, tribunal secretary paranoia is not warranted. There were very few decisions, in the past 30 years when an award was set aside based on the participation of the secretary. And these were, I would say, rather unusual cases for current understanding. In one of them, all of the arbitrators were technical experts, architects and engineers in a construction case. And they appointed a lawyer as consultant, who then ran the oral hearing, who drafted the award that was on the record. And the arbitrators put before the Italian Supreme Court, where it was decided that they did not have any capacity to decide issues other than construction issues. So then the Italian Supreme Court said we did have a fourth arbitrator in that case and set aside the award. But that is very much an exception based on unusual circumstances.
So if I just may have one follow-up question, do you think maybe that encouragement to use the secretary may come from the parties? Like maybe the parties can suggest, do you think it would be appropriate, or this is strictly in the function of the tribunal to present? Because we have the structure from the other side. We have the structure from the tribunal. The tribunal is proposing the secretary, as you mentioned, you said they will send in CV. But if you have, do you think there is even possible for the parties to propose that the tribunal should take a secretary as an aide?
I think the proposal is certainly possible and valid. And we actually have historical examples of that. We have arbitration agreements in a case that is more than 100 years old. It concerns the Urquhart concession in Russia. But in that case, it's just interesting, to answer that question. We had an arbitration agreement providing for the appointment of a secretary to the tribunal by each side. Not something we see today, and I don't think we would see many cases today where the parties do propose to appoint a secretary. And that proposal would certainly be possible. I'm not sure whether they could dictate it for the tribunal to appoint a secretary. Just because the secretary position does not only concern the conduct of the proceedings, it also to an extent concerns how the tribunal discharges its mandate. And there are certain, things within the internal deliberation process and functioning of the tribunal that the parties might not be able to dictate.
Bronzy, what about you? What do you think about that? Can the parties request a secretary or not really? Is it the tribunal's discretion only?
In the spirit of party autonomy, of course, they can request it. It wouldn't be the norm. And again, as Ola said, it's probably ultimately up to the tribunal, depending on the circumstances, but I wouldn't rule it out. Although I would have to say to the parties, we have a saying in English, I don't know if you can translate it to Polish, but better the devil you know than the devil you don't. So if I was the parties, I would encourage them to welcome the tribunal on board.
Right. What about, do you think the parties can object to a specific candidate that the tribunal puts forward?
Absolutely, they can. I would hope they would only do it with very good grounds. So not just a, no, we don't want it, but perhaps a conflict of interest. Because the tribunal generally comes from the tribunal's, the secretary generally comes from the tribunal sphere, there shouldn't be a conflict of interest, but there might be under certain circumstances, like if the tribunal secretary has already a previous connection to the dispute that doesn't exist with the arbitrators themselves. There could be other reasons, mainly that come after the appointment, like if they acted in excess of their mandate. But yeah, I would hope that they reserve a challenge for where it's really appropriate.
Right. Okay, so now probably something that all of you might want to hear, including me, absolutely. What would you advise to younger lawyers that are trying to get these appointments? What is something that they should do, they should start doing to get to be a secretary? And this is a question to both of you. So maybe Ole, if you could start.
I think for what it's worth, the answer to that question is easier than how do I become an arbitrator? Because as Bronte just said, the secretary position is very much connected to the arbitrator. And so my answer to the question, how do I become a secretary, would be find an arbitrator who is appointed, more or less regularly, and then see, how can you get involved? In most cases, it would be joining the arbitrator's law firm in an associate position. But there are other ways. For instance, my first appointments I received from my doctoral supervisor, and he often sits as arbitrator, and then sometimes he also uses secretary, sometimes he doesn't. That was an option, getting to know him and voicing my interest in the position. And I think that is something that would be necessary to talk to arbitrators about your interest in doing it. But yeah, other than that, I'm aware that other than the Polish court, there are other institutions who provide secretary lists of individuals who are qualified, willing, and able to act as secretary. I'm not sure how often these lists are actually used. Whether a tribunal would be in such need of a secretary and wouldn't have an assistant, in their own vicinity, that they would consult these lists. But yeah, that is something I'm not aware of, but it might not hurt to join these lists either.
So I can only echo these sentiments. Find arbitrators in your network and let them know that you're interested. An arbitrator once told me that you only need to be interested and intelligent. And I would maybe change that a little bit. You only need to be interested and well prepared. So go for it. And if you're lucky and you end up in a disputes team or an arbitration team, you probably won't have to look very hard.
Maybe as a follow-up, do you think there should be minimal requirements to what that person has in his or her education or experience? Do you think there's a threshold, or do you think it should be just the person who is, like you're saying, intelligent and well prepared?
That's a very interesting question that I haven't given any prior thought to, because the role of a secretary only came to me post bachelor and master of law. It's maybe not regulated. So perhaps there is wiggle room there that you don't necessarily have to be a lawyer, at least not that I know of, but I can't go on record saying that right now.
I agree. It's an excellent question and definitely one thinking about. And I might imagine that, you know, appointing someone not as far advanced in their career might give some comfort to the parties. If you appoint a student, for instance, it's quite clear what her or his task will be, which will be very much limited to, you know, administrative issues. So I think there's no real downward barrier, I would say. There might be an upward one. You know, I talked about the Swedish case where a professor was appointed as secretary. I think that's a more relevant question to think about, whether there's an upward barrier for acting as secretary.
Right.
And just to add on there, sorry, maybe that's where the interested comes into it, because, you know, if I was in a totally different field, I don't know if it would even interest me to be an administrative secretary, but you never know.
Anya, I think no. Okay. Right. Thank you so much. I think on the other hand, it can also, you know, it's a question, because you're saying that it can provide comfort if you have lower qualifications, let's say, but at the same time, if, for example, the secretary might have some other tasks that might not be limited to only administrative tasks, maybe those minimal qualifications would be not enough to be able to work through evidence, to be able to prepare the summaries for the arbitrators. What do you think?
Absolutely, I agree. And I think what it really comes down to with the entire secretary discussion in many cases is arbitrator due diligence. Right. So I would certainly say that if you're able to, you know, have a word in who is the presiding arbitrator as a party, you might, you know, want to look closely into how do they handle secretaries. You know, is it possible to find that out in advance? And I would be very surprised, you know, if there are many experienced arbitrators who appoint secretaries who are not able to handle whatever they need to handle. But yeah, I would say, you know, the best way to prevent disappointments is well executed due diligence as well.
Okay, there you go. I had to obviously speak on mute, that we wouldn't have a webinar if someone didn't do this mistake. Anyway, last but not least, and to make this a little bit more interactive with the audience, we prepared a couple of questions to the audience to better understand where you stand as audience on the topic of tribunal secretaries, and what is your reality regarding these appointments. So we will have 4 questions, and Agnieszka will put them up. It will be in the form of a poll. So we will have the first question appear shortly, I hope, on the screen. Please click. We have quite a bit of participants. Please answer these. We will later discuss about the results. We'll show you the results and we will discuss. Okay, so I see we're already voting. That's perfect. So the first question, sorry, if you're just listening to us and not seeing the screen, the first question is, have you already sat as a tribunal secretary? We're trying to see how many of you already had that experience.
We have 24 answers out of 36. So, and I think that the pool, as we see it now, it mirrors the numbers that we discussed earlier. That there is still a space
for improvement.
For improvement.
Absolutely.
Yes. Okay, I think we reached 1 minute, so maybe we can. And the 24 is still. We don't see more people voting, so maybe we can move to another question. So it's 24%. Oh, we already have a second one.
Let's go through the second one. I just hope, I'm just looking at Agnieszka, and I hope we'll see the results later. We can go through them again. Perfect. So the second one, the second question is, if you already sat as a tribunal secretary, was your appointment official? So were you officially notified? Were you officially appointed? And this is a closer result, but still on the negative side.
But we can see the more reluctance on answers. We have only, so we would seem that the 17 people had the experience. And only 59, well, oh no, it's changing.
So 60% no, we're not officially appointed. All right.
Maybe just one quick note on that question. I mean, also the previous one. The question that comes up is, of course, when are you a secretary? Are you a secretary if you research an individual point for the arbitrator? Are you a secretary if you research a point and summarize submissions? Or when do you become a secretary? And I think, again, there's no clear answer to that.
Absolutely. Should we go to the next one?
Okay.
We will have the results shared afterwards, right? All of the 4 questions.
The next one is for the council. Would you as council in factually complicated cases request the tribunal to appoint a tribunal secretary? And this is interesting. So far we have 17.
Almost 50-50 there, moment
50%. Yeah, so this is very interesting. I hope you as audience will ask questions or comment on that, because I would love to hear about this actually. Okay, I think the voting slowed down, so we have 57 and 43%, so almost half, which is interesting, because I think more personally, I would think that these would be more to the side of yes, obviously in actually complicated cases, I would want a secretary, a help to the tribunal, but let's leave that for later.
And I think we have the last one.
Yeah. And this is about remuneration. So are you willing to cover the additional expenses of appointing a tribunal secretary?
Which position is you in? You as a party, you as council, or just in general?
I think we assumed as a party.
As a party,
okay,
because it goes to the.
We assumed as a party, but this is a good point that it could also be a question to the arbitrator whether they want to share their portion.
Or to the secretary. There was one proposal a few years back that secretaries should act pro bono to get the education and the experience. And I would certainly say it's very valuable, to have that experience. But acting pro bono might not be feasible in all cases.
And it's a lot of work, I would assume. All right, and here we have, out of the 22 people that voted, we have 36% for yes and 64 for no. So you're not willing to cover the additional expenses of appointing a tribunal secretary. So thanks a lot for the voting. Agnieszka, I'm looking at you over there. Can we in some way see all of the results together? Is that possible?
No, we can see it one after another. So
maybe that we can do that. We can go through the answers again, or the results, sorry. And Oli, Bronte, if you want to add anything on the results, please do.
Okay, so now the first question, I will share the results.
Right, so we have 76% for no. The audience did not sit as tribunal secretary. So this is probably something that we talked about. But if you want to add, please do.
Yeah, I just think Ola made a great point earlier about how you would define this. So between us, if I was writing my resume, I would probably define it quite loosely and include the times where I have assisted, for example, a co-arbitrator. But yeah, that could also have an effect on the numbers that we see in the poll. So maybe people thought, oh, when I was officially appointed, without seeing the second question.
All right, can we pull up the second one maybe as well?
Yeah, just stop share. And now the second question, share results.
That's a very interesting result.
There you go.
Yeah. Not surprising, I guess, but 63% of the people who already have an experience were not officially introduced as a secretary. So we definitely have room for improvement here.
And it's still better than 10% or 1%, I suppose.
Yes.
Although maybe with regard to the 10 and 1%, it's also important to note that, of course, not every single case lends itself to appointing a secretary. And especially for, younger newcomer arbitrator, first-time arbitrator, it might be good to do quite a bit of work yourself, I suppose. And then the question arises, which case is suitable for a secretary?
Okay.
Can we move to the third?
This is something that is interesting to me. Like I said, I think in factually complicated cases, you would think that a tribunal secretary would aid the tribunal into going through the evidence in these administrative tasks as well, which is in factually complicated cases, construction cases, for example, it's quite a bit of work. But it's interesting to see that the results are 50-50.
And I think actually, sorry.
Sorry, you go, Ola.
I think that question basically ties in together with the next one, because if you as a party actually were to ask the tribunal to appoint a secretary, I think it would be very hard to say, but dear tribunal, you pay for it. If you make that suggestion, I think it's clear who pays.
I was just going to say, I would like to know the reasons behind the no, in true lawyer fashion, not accepting an answer. And if it's something to do with paying, or if it's because quite simply that the parties don't feel comfortable requesting that from the tribunal because it's not the norm. That would also be interesting to understand.
And we have one comment from the audience, and it connects what you just said, and also to the fourth question. So Agnieszka, if you could just put the fourth result, it's what argument would you use to convince the client to pay? I find none. And I think that, of course, it depends on the assumption whether the payment would go from the pool of the arbitral tribunal or extra. So I think it all depends. And if what you just always said, that if you suggest that if there is a complicated case and there's a suggestion to have someone who will help, that it will automatically have a little bit of an impact on the remuneration and the fees.
Yes, and I think it's the argument is a lot more difficult if you talk about ad valorem remuneration for arbitrators, where, as you said, there's one pool of fees they receive, and then out of that, everything needs to happen basically. The argument might be easier to make in per hour cases where arbitrators are paid per hour, because the secretary would be paid at a lower rate, and the hope would be that certain work that the tribunal does not need to do personally, these administrative things, could be carried out at a lower rate by the secretary. And then you could tell your client, it saves a little bit of money. Whether these in practice work out is a different question.
That's what as far as I remember, LCIA has a framework framed on the hourly remuneration. So that, and I think that also ICA also proposed a minimal remuneration level for the secretary, but it was 2014. So I think it would be a little bit adopted.
Thank you so much.
Thank you very much.
Thank you very much.
Thank you.
Thank you very much. Bye-bye.
Goodbye.